Live. Good morning. We're back live and continuing our discussion of H548, the miscellaneous cannabis bill. And our next person on the screen is James Pepper. And Pepper, I hope, you know, I want to get to mark up the bill, working with Michelle and you on getting the final version ready to get out of here quickly. So I would appreciate any comments you have on first the caps.
Sure. For the record, James Pepper, the chair of the Cannabis Control Board. So the cap.
Hold on just a minute.
Oh, sorry.
So James, so some of the witnesses in talking about the caps, I think we're talking about what was in the bill as introduced, and then some on the other part. And so I printed off the language with regard to those caps because it's not in what came over from the House. Are you going to be talking about that? Because I'll give it out to them, but if we're not.
So the caps that I heard discussed today were the solid concentrate 60% THC cap, the 30% cap on THC flower, and then a cap of 50 milligrams per package on edibles. And I could touch on all three of those or however.
I'm going to give them section 1 of the bill as introduced, so that because that language isn't, you can't see it in the House proposal.
So the House took out the caps.
That's right. They left something in with regard to the exemption for the packaging, like when you but this section that I just passed out to you, they took out.
Okay, thank you.
This whole thing, yes.
And you would like this back in?
Well, look, I'd like to, if you don't mind, just give a brief description of when you hear the word, recommended by the CCB or recommendations that we've given. We're not a policy group. Essentially, we were asked in Act 164 and Act 62 to evaluate a couple of policy areas, look at what other states have done, and then make a recommendation back to the legislature as to whether or not they could exist here and how we would regulate them if they did exist here. So, it's hard for us to really advocate for anything that we don't consider mission critical to creating a safe, effective, and equitable market, which is really the purpose of the Cannabis Control Board. So we have a 14-member advisory committee. It's made up of political appointees that represent municipal expertise, expertise in women and minority-owned businesses, criminal justice reform, law enforcement, public health. And that really is an advocacy group. They are there to help us, guide us, and make and evaluate these policies. And every single recommendation that's come to you through one of our various reports has been vetted by people with expertise. And it's been done with the help of our consultants looking at comparisons of other states. So one of the questions that we were asked to look at is, should you allow greater than 60% solid concentrates sold not to the public, but to in between supply chain from licensee to licensee? Essentially, this 100% THC is essentially an ingredient in things like edibles. They can be diluted down for the final product, but to say that they're prohibited throughout the supply chain was causing some problems, and the legislature asked us to look at that question. Should they be permitted intra-supply chain? We posed that to our advisory committee. They said, absolutely, you should allow it. Imagine trying to cook with sugar or salt, but the only salt you can get is, salt that's mixed with butter or something like that. It just didn't make sense. But then they took it one step further and said, actually, when you dilute a solid concentrate with some sort of solvent or some kind of adulterant to dilute it down to 60%, usually that adulterant is more deadly or dangerous. We saw this with the vitamin E acetate and the EVALI lung issue. That could be potentially more dangerous than the concentrate itself, the high THC above 60%. So that was the recommendation that we made to the legislature. We had a long discussion in the House Gov Ops about this. They do not feel comfortable with this. And honestly, the science is evolving. It's really hard because of the federal status to have any longitudinal studies about additives or solvents that are added into cannabis products and what the effects of those are. The board is going to take a very cautious approach when it comes to additives, especially when it comes to inhalable additives. While we stand firm behind what we recommended, I don't know if I don't know if the board, I don't know if there's enough time this session to really kind of walk through and do it, sufficient education, or if the science is even there for us to definitively say that we need above 60% concentrates in this bill. I can talk about the other cap, the THC caps on flower, the 30%. That was
I am totally confused now. I don't know what you want, what you don't want in the bill.
So I'm confused. Did they take out this whole thing or just what's crossed off?
No, so section 1 that I just passed out to you is the House removed it. It did not come over in the House proposal of amendment.
Okay.
People were talking about caps. The witnesses, various witnesses were talking about caps, and they were talking about these caps that are no longer in the bill. They're also talking, I think that they were talking about a provision that is in your bill having to do that when you have a packaged product that there is a cap on how much THC can be in that packaged product. And there is a provision in here exempting oils and tinctures from that cap. So there's caps in 2 different places. The language I just passed out to you is no longer in there. I just wanted you to see it because I thought it kept getting raised.
So I need to ask one more question. They took this section out.
Mm-hmm.
Why are 2 and 3 crossed off to begin with?
Because that was the proposal as the bill is introduced. Initially, the recommendation that had come from the board was that language in sec 1.
And
The House-
they recommended crossing off 2 and 3.
Yes.
The board did.
The board did.
Okay, so, and then the House just took out the whole thing.
And the House took out the whole
Okay.
section. Yep,
Yes, I got it.
okay.
Question, do you want this back in the bill?
Yes.
So it's good. We believe that it is good public policy that the cannabis board can do better than the black market. We will, it's the same rationale as for why you do tax and regulate to begin with. We will have a tested, safer product on the regulated market. And the black market, I can tell you, is happy to supply high THC concentrates. They're going to do it using butane, hexane. They're going to leave adulterants in there. But, the bill, it's H548 as it passed out of the House, does so many important things that are absolutely critical that, if that's the compromise to get it over the finish line, then I understand. There are a lot of unknowns. There's a lot of education that needs to happen still. So while we stand.
Putting it back in.
Okay, Senator White has moved, we put it back in the section 1 that you see here. Is that okay with everybody?
Including what is crossed out, is
Yes.
that correct?
The Cannabis Control Board recommended crossing out those 2 things.
So you want this,
Put it back in.
the
Yeah.
whole thing, and does that include what the board crossed out?
Yeah. And well, I mean.
That is the amendment,
That is,
because the up to
This would
the,
be an amendment to H548 as seen
right here,
right here.
just as it is.
Well, it's not gonna be just as it is, because
Yes.
2 and 3 are crossed out.
Yes, and they will remain crossed off.
Senator Sears,
Yeah,
I'm wondering if Michelle could share the screen on that amendment?
well, we're trying to keep it away from you.
This is on a need to know only basis, Philip.
Yeah.
I-
I'm
don't
trying
think
here
you
to
can.
save the day with a plug for my laptop.
But this is
I'm
creating.
90%. 90%
We
willing
will
to go
share
on
the
Pepper's
screen as soon as
recommendation.
we can, but it's creating a technology issue for us.
Okay, I think from
Yes.
the description verbally that I support it, but I'm hesitant to vote for something I haven't seen
You
it.
do,
I
you do
don't
support
blame
it.
you. I don't blame you.
You do support it,
Um,
Bella.
Is there a way to email this to Senator Baruch right now?
Yeah,
Oh.
yeah, if you have that, Michelle, you want to email it to me, I can share it screen real quick.
That document,
Yeah.
just pull up H48 as introduced.
Or email it to her.
If section 1 of the bill is introduced. And
Oh,
there was-
Alice is sending him a picture.
and there was a-
What,
Alice is sending me a picture?
Yeah.
Already, if I.
She's texting me?
You can just look at it in the mouth.
She's sending you a picture of a flower.
What page?
It's section 1 of the bill as introduced. And there was a Senate companion bill that's the same.
Okay, I see, hold on. Okay, here we are.
There we go.
Got it? Oh, there, okay. Okay.
Can you go scroll down, Peggy or Michelle?
I'll sit section 1. Is that where you want to be?
Yeah,
Is
yeah,
there any?
just go to just go to number 4.
Oh, sorry.
Yeah, just a little further. There you go. That's it.
Okay,
And just a reminder for everybody, so, this section, which is prohibited products, was something that the House added when you were working on S54. And then it was included in the conference report as part of the conference committee kind of trade back and forth. And so the Senate agreed to accept the prohibited product language. And so that's in current law, which is why most of it is not underlined. And so what the CCB had initially proposed, which is in the bill as introduced here, was that subdivisions 2 and 3 be struck based on what Pepper had mentioned. And then House Government Operations took the bill up, but they decided not to include section 1 in the bill that they sent over to you.
All right, so
Okay.
I'm recommending that we put it back in.
Okay, so that's number 1. You can take down the screen sharing now, Peggy, thank you. Okay, so everybody's agreed to put that. Next issue is,
Yes.
we decided that we wanted to make clear that you do not have an integrated license, does not provide you with the ability to have 2 licenses.
Yes, if you have an integrated, if you are a holder of a current dispensary, you can have 1 integrated license, that's it.
Right. But if you own 2 dispensaries, can you have 2 integrated licenses? The answer is no.
No.
So
I
we
think
want to
not.
make that clear. And Michelle has an amendment that would make that clear. She could share that with the screen right now, or.
So,
So in effect, there would be 3 integrated licenses available, because there's 1 standalone, there's 2, somebody owns 2 and somebody else owns 2. So of the 5 dispensaries, there's 3 owners. So there would be 3 integrated licenses, is that right?
Yes.
Yes, okay.
So the laptop won't connect to the internet, so I can't pop that up.
So what do you want to share?
There's nothing to share. So on the issue of the integrated, so last night I was emailing with Bren with regard to language on the integrated issue and on the background check issue that they raised last week. And so I'm in the process of working on an amendment for y'all now, so I don't have that language up, but what you've said is correct, which is that if you look at the language that was originally adopted, is it talks about only 1 license. You know, people can't obtain more than 1 license, but I think in looking at it subsequently, it's a little unclear with regard to the integrated licensees because of the common ownership of a few of them. And so what you're doing in the amendment, it would be to clarify that when you read that together with the other provisions in the act that you passed, which says that you can't have more than one license, that when you read those together, that you're just clarifying that the original intent was that it's a one-to-one.
So
Yeah.
you don't have that amendment ready yet.
No,
When are we gonna, what other amendments do we have?
so there's the integrated license issue, there's the fingerprinting issue that I'm gonna be going back and forth with the board on, and then the one that you just mentioned with regard to adding section 1 of the bill is introduced back
We
in.
did.
There, Senator Sears. There was also the child-proof packaging issue, and I was talking with Pepper about that at another point. Pepper, I'm wondering, was there any further work done on that?
Yes, there was. So essentially, the issue with the child resistant packaging, which is what's required by law, is that child resistance is a federal definition, and there's a process that people have to go through to have their packaging tested to make sure it actually meets this federal definition. And it requires, as I mentioned last week, a lot of plastic. We have one of our board members used to work in bioplastics in DC, and the claims that they are compostable are largely false, or they're compostable under very specific circumstances. And we've also talked with kind of waste management here in Vermont. A huge number of the quote unquote recyclable plastic slips through is small enough that it slips through their kind of sorting system. So it's not going to be recyclable. It's not going to be compostable. What we thought might be kind of a third way was there is a terminology called child deterrent packaging, which is recognized. What child deterrent packaging is essentially it is greater than, it's not child resistant because it hasn't gone through that comprehensive testing with 5-year-olds and being able to enter the packaging, but it is something that we could define, and we could have characteristics, and we could say things like it's tear resistant, or it's got a locking mechanism, but it wouldn't require this kind of heavy duty non-recyclable plastic.
I would be okay with that. And this would be exclusively for flour, right?
Just flour, anything that is psychoactive upon kind of consumption or upon, touching, child resistant packaging. We recognize the public health risk here. And we don't want to subject young people, we don't want to subject anyone unintentionally to edibles or anything that might result in a hospitalization. That's just not the case with flour. And so, yes, short answer is just flour.
Okay.
I think that sounds reasonable.
Okay.
So I was able to get online, so I can walk through the House, what passed by the House, just so you can see it, make sure there's no other recommended amendments that you have.
Okay.
I can have it ready for you tomorrow. You guys are
I want to look at my agenda for tomorrow.
While you're doing that, I'm looking at these labels. The medical society label only says that it can cause psychosis, addiction, uncontrollable vomiting, or harm to fetus or nursing baby. I think ours is much more comprehensive. I mean, it says that it's not approved, there could be legal consequences, there could, I don't, if they're saying that's all they want.
Okay.
Okay,
Let's walk through.
I'm just gonna walk through quickly, so.
This is the bill as passed by the House.
Right,
So, I've already,
so we'll just go through, make sure there was nothing else that anybody wanted to bring up. So section 1 is allowing the board to regulate synthetic cannabinoids. Section 2 is an A1I, directing the board to do rulemaking around additives, including cannabidiol derived from hemp. On page 2, you'll see the addition of what we were talking about around caps for certain products, and this is exempting solid concentrates, oils, and tinctures.
And that says that it can't be over 50 milligrams, right?
But it's exempted from that.
Oh, it's exempted
Right, so if
from
you're
that.
going
Okay,
to
great. Got it.
purchase, right,
Yeah.
so right now, their concern was that if someone was going to purchase a tincture, it would be over that, and this is intended to not apply to those tinctures and oils.
So they could be,
Right, but if it's a
60 or
cookie
80.
or something else, it does have to adhere to the cap.
got it.
There's also in the rules concerning retailers, elimination of the requirement that if it contains any kind of hemp, that it be displayed separately, but it does have to be labeled. Section 3 is the employee identification card issue, and so this is making it so that it's basically you get approved by the board to work in the industry rather than it being tied to a particular employer. I will just mention that this is one of the sections that I'll be amending, kind of looking at the issue of the fingerprint supported background check from FBI and kind of adding in language with regard to the solution that the board has come up with regard to making sure that they have the background checks they need. Page 4, section 4, this is to allow one person to hold more than one testing laboratory license. This will be where the language is clarifying that if you own more than one dispensary, that does not entitle you to own more than one integrated license. Section 5, retailer license, this is just adding, clarifying that retailers are allowed to package pursuant to their license. There was an issue, and I don't know, it came up from Chair Pepper around delivery. I'm sorry, not delivery, online ordering. And so currently for retailers, online ordering is prohibited. And I thought that James had brought up the issue of online ordering, and I wasn't sure where. I thought he was in discussions with the chair, other folks about whether or not you guys were okay with online ordering.
Can I just clarify that this would be online ordering for in-store pickup? So all of the security and ID checks and purchase limits, all of that would still apply. It really just is that you could order in advance and then go and pick up and pay and have your ID checked at 2 different points. It really, this is, I think the hallmark of every adult use market is at the outset of the market, especially. There are lines around the block. There are sold out shelves. There are people that are waiting in line just to realize that there's nothing left by the time they get into the store. We want to avoid some of that to the extent that we can. And it's really a function of that the demand is going to outpace the supply, especially early on. And online ordering is permitted in all but 2 states, all but Maine and Montana. And most of those states were silent on it until the pandemic, where they had to pass emergency rules, emergency legislation, emergency rules to permit online ordering as a social distancing mechanism. It just, and by the way, we were required to kind of report back on whether we should allow online ordering pursuant to Act 62 last year. And I don't think that there really are any public health or public safety concerns with it. I may be it might be in my blind spot, but we do think that this is part of an effective market.
I'm fine with that.
Yeah, all right, we can add we'll look at an amendment, that amendment tomorrow as well.
Can I just add, Senator Sears, I totally agree with this. I can't think of a logical reason to oppose it. I'll say that on the public safety side, it has people in the store for much less time, prevents lines out the door. It just allows you to order the whole process. So I've never understood really the hesitation unless somebody is hesitating about creating a registry of names that might be hackable, or they have some paranoia about the online process generally. But it just seems like common sense to me.
My wife and I have started ordering food online. I mean, you know, we go down and pick it up at the restaurant rather than eating rather than eating in the restaurant during COVID. Actually works fairly well, so.
So moving on to page 5, section 6, that is just
Who's this?
suspenders already, they have to have it independently tested. Section 7, this is the striking the language with regard to the dispensaries being able to use certain chemicals for creating concentrates, no longer needed. Section 8, this is just clarifying that the caps that were lifted on for dispensaries to be able to transfer product to integrated licensees, that has an end date of October 1st.
Yep.
And that's it. And
That's
so,
simple, little Bill.
right, and so what I have for these is I have the background check issue, I have the flower packaging issue, we have the integrated license issue, we're adding back in the amendment to prohibited products, and looking at allowing online.
Okay, we have 2 issues left. One is the labeling and the other is the fingerprint.
So I can discuss labeling if it's helpful.
Screen now. I'm sorry, Pepper, I didn't hear what you said. You can discuss which.
Oh, if you'd like me to just, just respond about labeling briefly, I know that I spoke last week, but I can just, I've done a little bit of research since last week on Colorado. And, essentially, I think, my background, I've got a background in criminal justice and, other issues. Our other board members, have background in human resources and agriculture. We're not the people that should be deciding what should or should not be in a warning label. We share all of the goals of the Medical Society and Dr. Stout and Dr. Roberts, that we want evidence-based, accurate, helpful information, particularly for kind of first-time consumers of cannabis. The best that we could do was just give this over to the Department of Health, and of course, the problem is that the science is evolving as more states legalize and more people are exposed to cannabis. The science continues to shift. Our warning label that we have applies to all cannabis products. The warning label that passed in Colorado and is now required, it is only applicable to concentrates. And I think it highlights an important point, which is that, I think Senator Sears, when we talked to one of the chief enforcement officers in Oregon State, early on, he said, he was a former law enforcement officer. He said what they were seeing in Oregon was that people were having, alcohol poisoning because smoking cannabis can suppress vomiting. And so they're not being able to kind of expel the alcohol from their body after they've drank too much and then had, a little bit of cannabis. And what this warning label is saying is kind of, well, actually it can cause excessive vomiting. And it just highlights the point that, and that's true, I think, potentially it's starting to become true, with respect to these, or there's more and more cases of it with respect to high THC concentrates. And so really, having a universal warning label set in statute, I really think is a bad idea. We will continue to just allow the Department of Health to tell us what should be on this warning label. And I think that, you know, if the Vermont Medical Society or other groups want that changed, I mean, we are open to changing it. We just need someone to rely on that can actually kind of vet the language and make sure that it's science, evidence-based and supported.
And James, can I jump in here? Sorry, Senator Shears, right?
Go ahead.
I just want to make sure I'm clear when I go back to Elkhart and explain what's happening here. To tee this up for the entire committee, Elkhart was listening to the conversation. We had an understanding that labels were being applied, that the label decision had been made before Colorado decided to change their label. Elkhart heard that, came back and said, well, this really isn't an Elkhart discussion. It's for the committees of jurisdiction to have that conversation. As I understand what you're saying right now, the entire label conversation really shouldn't be cast in statute by this committee. It should in fact be left to the Department of Health, and it is an ongoing conversation. Does that pretty much summarize the picture thus far?
That's absolutely right. And honestly, that's what happened in Colorado too. There was a concentrates bill that limited the amount of concentrates a single person could purchase per transaction. And in that bill, there was a directive to their marijuana enforcement division to create a new label for concentrates. But the directive was work in consultation with the Colorado Department of Health. And so that's how that new label, which is now just for concentrates, came to be. And you know, they took testimony just like the board does. You know, we took extensive public comment on our warning label, but ultimately we said, you know, if the department, unless the Department of Health wants to change one comma on what they did, we're not going to do it. And unfortunately, I think that's why, you know, everyone started shifting their focus to Elkhart, when really, you know, and I think the Department of Health is willing to meet with anyone and consider all of these ideas. It just, they had done a process, they had gone through a process, including public comment. They came up with the label they thought was most appropriate. And if that needs to change, we will absolutely change it, but we need to kind of rely on them to do it.
I would suggest that we not put anything in statute except that the Cannabis Control Board continue to work with the Department of Health on ever-changing potential
I agree with
labels.
that position, Jeanette, because Elkhart is a quicker place to have a new rule come through than it is the statutory process, which would delay things and actually potentially exacerbate a problem that might be legitimately raised, because it takes so much longer to get legislation through the system.
Yeah.
So James, I appreciate it. I think I've got my answer to go back to Elkhart with, and that's very helpful.
So we're just gonna trust the Department
Hold
of
on.
Health.
Yeah,
I'm sorry.
I think that we ought to reiterate that it is the responsibility of the Department of Health for the labeling. And if that means putting in a legislative intent or whatever, that the Department of Health will determine it. I'm going to speak to you now as somebody that worked for 40 years with kids that your mother told you not to play with. And you put something like this in, they are going to laugh their asses off. Excuse my language. But cannabis disorder causes uncontrollable and repetitive vomiting. They are gonna, that is not gonna stop somebody from using it. And I'm reading from Colorado. I'm sorry, you have to use a little common sense when you make these warning labels. I know how kids react. They're gonna use it to say, it didn't cause me to vomit, therefore, this is all BS and the rest of it is. So you can disagree with me all you want, ma'am, but I spent 40 years with those kids, and I can tell you, they're gonna laugh at that.
Well,
Can I ask a question? My hand's up. Can I ask you, James? So James, I have two pictures here of labels, which I think are the labels that you're going to use. Is that true, or are you still working on the label with the health department here?
So the labels I assume that you're looking at are from our rules, which have been approved and adopted by the board. So the label is going to, the label that begins cannabis has not been analyzed or approved by the Food and Drug Administration. If you're looking at that, that's the board adopted warning label. And then we also have a symbol, 2 symbols, keep out of reach of children and contains THC. Both of those, again, were approved, created by and approved by the Department of Health.
You can say, so James, you can say to me, this label that I'm looking at, that you just started reading from, is the label that the Department of Health has established as the label that you will use. Is that correct?
If it's the one that begins with cannabis has not been
That's it.
analyzed or,
Yeah.
yes,
That's what
then
we're
yes.
looking at.
That's it. And they were actually required to report back in January to the legislature about how this process, this collaboration worked with the cannabis board. I don't know if they ever submitted
Yes.
the Department of Health. I don't know if they ever submitted that report, but I can tell you that we just gave this project over to them and they did it. And we, you know, when the public comments started coming in, oh, you should change this word, or you should have this instead, or this part should be bolded and not this part. I sent all of them to the folks at the Department of Health that were vetting this, and their response, and you know, generally they are pretty busy over there, was we prefer you not change anything. In fact, that standard symbol, the contains THC, subsequent to us putting it into rule, the ASCM, like the international standard, adopted a international contains THC symbol, and it's yellow instead of white. And we asked them, well, should we just use this? This will be the standard symbol moving forward, you know, probably, especially if there's federal legalization. And they said we went through a process, we prefer you use what we gave you. And so that's what we did.
These two.
Okay, I don't care about those symbols, these people, nobody knows.
The most important label is unedible. People learn to go slow or whatever. So that's where a number of the problems cropped up.
Does it say it on edibles?
I don't know what it says.
Oh,
This label goes on everything. And it says, cannabis can be, oh, there's a thing here.
Yeah, but is it handed out or is it?
The effects of edible cannabis may be delayed by 2 hours or more. It clearly says that. So it's telling you that if you're stupid enough to take it and expect to get high right away, and then so you keep eating more and more, which is what Maureen Dowd fed her silly dog, then really, but it says that very clearly there, and it's highlighted.
I see it.
Michelle,
So I just wanted to, let you know, there are, in here, there's 3 different places where you direct that labeling is to be done in consultation with the Department of Health. On cannabis products, you require in law that they're labeled with the date that the product was manufactured, the date the product is best used by, the ingredients contained in the product, information on the length of time it typically takes for products to take effect, and appropriate warnings developed by the board in consultation with the Department of Health.
Right.
So that's required for just
did
the
you,
products, and then you have other places in there where it talks about labeling cannabis and working with Department of Health, on advertising, and then also there's a point of sale flyer that has to be given to customers, and that's to be developed with the Department of Health as well.
can you print out that's part of S54, right?
Yeah, you know what I'll do is I'll go through and cut and paste all the different places where, and make one document for you. So you can see.
That would be helpful, I think, for people that understand. Okay,
And
so
I think I trust our Department of Health.
This is not a one-time event, this is.
Senator Drew, did you have a comment or question?
Nope.
Or you're petting Julie?
Yeah, I was petting the dog.
Is Julie the dog?
Yes,
Oh,
yeah.
okay.
Let's hope so.
I didn't know.
Those of us who have dogs while we're zooming in from time to time have opportunity to either feed the dog, give them a treat, or
Okay,
that's what I was referring to.
okay, got it.
Okay, we're almost
I
at 11:30, and are there any other things that we give direction to Michelle here for a redraft for tomorrow morning. I can look back at my agenda for
What
tomorrow.
was the fingerprint issue? Was that sorted out?
Huh?
The fingerprint issue, is that sorted out?
It's sorted. I'm going back and forth with the board on the language, so I'll have it for you tomorrow.
Okay.
Well, then cancel H399.
Just cancel it.
It's a simple little bill. We can vote it out in 5 minutes, but I got 14 people that want to tell us stuff.
What bill is
What
that?
is it?
What one?
Trust me.
Yeah, I've heard that before.
And then
No,
we're just taking it off.
I want to get this bill out of here
Okay.
and possibly get H505 out.
Okay.
So,
So do you want me to put here, 5:46?
yeah,
48?
yeah, 45 minutes would probably get us to get that bill out and see where we're at on 505.
Are we taking this amendment up tomorrow, 7:29? I never really heard if we were taking
What's
it.
729?
Evan, there was an amendment.
Oh, on fentanyl?
Yeah.
Yes,
We are doing that, okay.
yeah, that's an amendment on fentanyl that Evan's gonna talk about, but,
Oh, on 505.
yeah, on 505.
But then there was this, remember there was 7:29 amendment with Damien and Eric, there was another.
Oh, that bill?
That was a forwarded.
That's going on the miscellaneous judiciary bill and it's not even out of finance yet.
Okay, so we're not doing that one.
I don't, yeah, we could, I guess, but I don't. I'm not,
Remember tomorrow we're going to Judge Wakefield swearing in. Well, that doesn't matter for this committee.
1 o'clock.
What time is that, Alice?
1 o'clock.
Okay.
Oh,
So
tomorrow?
I'm taking this
Yeah, I
out.
told my committee we're not meeting.
Yeah, so 1 o'clock.
Yeah, put this
Oh.
on next week, but.
We have EMS scheduled.
No, take
for
that
all
out.
day, and it's-
We can do that next week.
Okay.
That should
I can
only
put it
take
for
10
an hour.
minutes. Thank you.
Well,
Dave.
go for that.
All right, we're gonna shift gears to a different bill. If we're all set on cannabis, miscellaneous. cannabis.
Thank you, James.
I
Thank you.
hope the day comes when I don't have.
Thank you.
On bills anymore.
I know.
It's a lot easier when we're just arguing should it be legalized or not legalized.
I know, yes or no.
The narrative has certainly changed.
Why don't we, Michelle, Jen Pullman is not able to make it.
She's here, so I was, and the bill is very
Oh,
short, so I thought
okay.
maybe you could just go to her and then I'll.
Okay, I thought she was canceling, so thank you for being here.
Thank you. So so for the committee's pleasure, would it be myself that goes first and then Attorney Childs follows?
What are we doing?
This is, you are looking at H553 and it is, as you can see, I don't know that you need much of a walkthrough from me. It's one line.
It was in the, it was from Peggy and your.
Yeah.
Yeah, we have the one.
Paragraph.
Well, I never look at the daily
That's where it is.
one. Because I always put them on, okay, well, never mind. I'll do Phillips, yeah, I left it for you, it's here somewhere. It's okay, I lost my folder.
Dependent means victim, spouse, domestic partner, or a person who is legally dependent for support upon a victim. To qualify as domestic partner, a couple should share a residence for at least 6 months prior to applying, by 18 years of age or older, not be married to anyone, and prohibited legally marrying one another. This effective date, section 2, shall take effect on passage.
Can I make one comment?
Huh?
Can I make one comment?
Sure.
On the age of 18 or older, could it be unless you're an emancipated minor?
This is just, this is the definition that Human Resources for the state uses. So that's why they chose that for over in the House, but you can decide however you want to do it, but I think maybe it might be helpful if you listen to Jen as to why she wants that, and then I'm happy to work with you on language.
Yeah, no, my only question was, because there are some emancipated minors, very few, but there are some, and they are treated like adults in every other.
Okay, Jen, I know you're on a time crunch, so go ahead, please.
Thank you. Good morning. For the record, my name is Jennifer Pullman. I'm the Executive Director of the Vermont Center for Crime Victim Services. And thank you for your time today. And I think this may be one of those times where I can actually say this is truly a simple bill that won't get convoluted in the process. I've been around enough to know that simple bills often don't become that, but I believe that this one is nicely gift wrapped towards the end of the session for you to be able to experience that. So by way of background, as you all know, the Victims Compensation Program is a program that we operate that's funded through special funds and federal funds that provides up to $10,000 of expenses to victims of crime-related expenses that they incur. Typically those are medical, mental health counseling, crime scene cleanup, lost wages, temporary living expenses, other sorts of expenses that are not covered by insurance and that we can cover within, almost immediately, simply with an affidavit of probable cause. So that's an important piece that we feel we can upfront support for victims, again, pretty quickly after a crime has been committed. And what we've found is that in looking at the statute, the simple definition statute under 135351, and that is on the committee's page, but that it's a sort of a hodgepodge in terms of how a victim is defined and how who is able to receive support is defined. If you look, and I don't know, oh, thank you very much, Peggy. If you go down to section 7, you'll see there's a definition of victims. And generally, we only cover expenses for direct victims of a crime. But in certain cases, we can cover, as you see under subsection C, when there's a homicide, we can cover expenses for other members of the family. And section C goes on to define who those people would be. In this particular section, you see that we can cover expenses for domestic partners, but only when it's related to the suffering of severe emotional harm. So we're able to cover counseling in those cases. Where that becomes problematic for us is if there's a victim or indirect victim who's a domestic partner who's seeking support for temporarily living expenses when they are basically trying to figure out how to, in this case, per our definition, when they've been living with the individual who was killed, when they have been sharing that property, where they have been dependent on that income to provide support. And now with the death of their partner, they are faced with a situation where they're not only grieving that partner's death, but they're trying to figure out how they're going to maintain living expenses. If you go up to subsection 2 and subsection 5 does allow us to provide, the last sentence reads that in the case of a dependent, pecuniary loss means the cost of psychological, psychiatric, or mental health counseling, funeral expenses for the victim, and upon demonstration of financial hardship, temporary living expenses. But when you look up at subsection 2, dependent is narrowly defined as only the spouse or a person who is legally dependent for support. What a reading of the statute means to us is that for a victim, for a domestic partner whose partner has been killed, we are not able to provide temporary living expenses in that situation. We only have about 1 or 2 of these cases per year. Unfortunately, since this bill was actually introduced, we did have a situation where a woman was the domestic partner of the individual who had been killed. She was carrying that person's child. She had lost her job just prior to the person being killed, and we were not able to provide any housing for that particular individual. So it is 1 or 2 cases per year, but it's extremely meaningful when we can think about potentially covering 12 weeks of living expenses that are capped out. So we do have a cap, but are capped out to provide them a chance to get themselves on their feet. So for us, this is a really important piece. It's closing that gap. It's making a difference in 1 or 2 cases. It's not a hardship to the state for sure. You all know that our budget is a little bit, certainly in trouble and up for discussion. But what is important to know is with any costs that we incur with, or any disbursements that we incur with respect to victims of crime and compensation payments, those are reimbursed 75% by the federal government. So in reality, it's really not a huge impact at all. Again, we're talking about 1 or 2 cases, but it is meaningful for that individual who suffers that loss.
Okay. Honey, I have one question. At the end of it says, and prohibited from legally marrying one another.
Here's who it is, I looked it up. This is who you
Means you're
can't marry.
related
You can't
by
marry
blood
a
and can't marry one another.
parent,
I
grandparent.
understand, but why is that there?
Yeah, I don't understand why they're
I
not
understand
dependents.
what that means, but I don't, so if you were gonna collect, you have the following requirements. You have to be 18 years of age or older, not be married to one another, not be married to anyone, and you're prohibited from legally marrying one another. I don't understand why.
So this
that's
is
there.
just the definition of a domestic partner, so it's trying to put the domestic partner on par with a spouse for purposes of being able to get covered for living expenses if your domestic partner or spouse is killed.
Mr. Chair,
Yeah,
I'm wondering, was that definition developed prior to legalization of gay marriage?
No.
No, this is the definition that HR uses?
It's tweaked a little bit, and I'd have to pull it up as to why, but the prohibited from legally marrying is just the consanguinity statute. So it just means,
Yeah.
and
I understand what it means.
Yeah.
I don't think I'm being clear about my question. My question is, why do we need that last phrase, and prohibited from legally marrying? Why don't we just put a period at the end of not be married to anyone?
Maybe they could change, maybe they could say my sister who lives with me is my domestic partner.
No, sisters, oh yeah.
Like with this removed.
But they can do that under the prohibited from legally marrying.
Don't understand you, Phil.
If I understand the language as it's in front of you, it would include sisters because they're prevented from legally marrying.
Well, the discussion here in the committee was taking out that last sentence, taking
Yes.
out and prohibited from legally marrying. one
I'm back to
another. So
not-
it seems like
I'm back to not understanding why it's there at all, because the only thing I could think about it that it was an artifact of a previous legal situation where you couldn't
They
marry.
just keep coming.
well,
no, so Philip,
Thank
it's
you.
saying that you wouldn't be permitted to marry, which is just saying that you're related by blood in a way that means that you couldn't marry. And so Alice's point, which is correct, is that you need that, or else somebody could say, my sister is my domestic partner because we share a residence and we're 18 years of age and we're not married to anybody else.
Right.
If you don't put in the prohibited from legally marrying one another, then you can include family members, and that's not the point.
Well, I guess maybe I'm with Senator Sears. I'm losing the sense of why we're making that distinction. If we're, I don't understand I don't understand maybe the definition or who we're trying to include.
you're trying to include a real domestic partner.
Well, but
Right, yeah, I just got it, I was going in the opposite direction and I just got it.
Okay.
So my parent cannot be defined as my domestic partner to be eligible for this. My sibling cannot be defined as my domestic partner.
Yes, that's
Yes,
correct.
even though my two sisters lived together and shared the whole household and everything, they were twins, but they could not be considered domestic partners because they were siblings.
Right.
Yes, got it, okay.
so it's the other way?
But
So
The other way
if-
means what?
I thought, it may be
You don't
because
get
I
it.
don't have the language in front of me, but I'm wondering why,
Can I share this and maybe you'll make this?
Yeah, go ahead.
Because otherwise, if my two sisters could have been considered domestic partners, if one of them had had been a victim of something and they wanted to give victims compensation, in this case, that's what we're doing here,
But-
that they would have been considered
Okay,
a
but here's
domestic, they could
my
have been considered a domestic partner, and they,
here's my question. If we're using the example of mother and daughter,
Mhm,
they're prohibited from marrying each other.
mhm.
So don't they then qualify rather than fail to qualify under this definition?
No, they don't qualify.
He's talking about taking out the last sentence.
They are prohibited from marrying each other, which is one of the requirements to be a domestic partner.
Correct.
Right,
But that's, the discussion is removing the last part, removing and prohibited from legally marrying. That's the discussion here in the committee that Senator Sears wanted. And not be married to anyone doesn't mean you're prohibited from marrying someone, because that last
Right.
sentence, last part of the sentence is gonna be dropped off.
yeah.
We don't want it dropped off.
If you drop it off, then that means they could be considered domestic partners,
Well,
if you drop it.
The question though is who is a dependent? That's the first word in the paragraph. And this has extended to domestic partners beyond the words victim's spouse.
Yeah.
I don't know what other paragraphs are in this series, but this is only paragraph 2 in a series of defined people who can get the benefit.
Right,
can
it's just putting domestic partners on the same, on
Same
par
plane
with a
as
spouse.
yes.
yeah.
And to be a domestic partner,
You can't
You
be
have to meet
married.
these
you
qualifications.
have to
so
meet
if,
these
let me
qualifications.
just make sure I understand that Joseph and Mary aren't married, but they're living together.
Uh-huh.
And Joseph and Mary, something happens to Joseph, this would allow Mary to collect. But if Joseph and Mary were sisters, I mean,
Siblings.
brother and sister, then they couldn't.
They would not qualify, she would not qualify as a dependent.
Why do we not want to allow a sister and brother who've lived together for 40 years, for whatever reason, to be able to collect, to be able to be eligible? That's my question. Why shouldn't they be?
The question though is, are they dependent?
Yeah.
I mean, that's what
They may
the-
be. Joseph may be disabled and dependent upon Mary.
So can I just, actually, Michelle, could you put that back? I am really having a hard time. Okay, so let's take the example of the mother and the daughter. So a couple shall share a residence, which they do. They're both 18 years or older. Neither is married to anyone, and they are prohibited from legally marrying one another. So under this definition, they are allowed to be domestic partners. It seems like it should say are not prohibited from legally marrying one.
It says and prohibit.
No.
So if you look at the first part of the sentence, to qualify as a domestic partner, you must be prohibited from legally marrying one another.
Which a mother and a daughter are.
Right,
Yes.
so you can't be a domestic partner if you're prohibited from marrying each
No,
other.
no, this is a definition of what is a domestic partner.
Yes.
So a mother and a daughter are prohibited.
Yes,
That
Yes.
is, so they, under this, they are domestic partners.
no,
Yes.
Not be married to anyone.
Okay,
and be prohibited from marrying each other. And they are prohibited, so then they're not domestic partners.
no,
No,
I'm
no,
sorry,
they
that's
are.
not right.
They are domestic. If we left this whole thing intact, it would
They
be.
are domestic partners.
No, they're not.
No, they're
Okay.
not.
They're not.
Okay,
And-
that's what it says.
And
I'm
you know
sorry.
what? I think Philip is right.
What?
No, he can't be right.
Wait.
I think he
Useless
is right.
right.
That's what I started with.
Qualified
All right, Senator
domestic
Sears
partner.
is right, not be married to anyone.
Okay, let's
And
stop with
not-
Philip's right.
Prohibited from legally marrying one another.
And not,
There should be a not in front of prohibited.
Exactly.
Yes.
not be.
Sorry, it took me so long to get there.
Yeah, not
But a
prohibited,
mother and a daughter would be prohibited from marrying each other.
Right.
not prohibited.
You're-
Was it Jennifer who said this was an easy bill?
No, I vote against it.
I should know better. I should know better.
So folks, with that, I'm gonna
If you
sign
add
off
the
and head
word
down to the
not,
building.
wouldn't you be doing what the bill's supposed to do?
Yes.
18
I'll-
years.
I'll see y'all in a bit.
And
Okay.
not prohibited.
Are you voting yes on the not?
He's gone.
And not prohibited. So it means,
No, I think if you put not in there,
and you screwed it up.
then you've screwed it up. Because they have to be 18 years of age, they can't be married, and they're prohibited from legally marrying. They
Yes.
are prohibited. These are the people that are prohibited, so they are not there. If you put they're not prohibited, then you're
Saying
saying they
married.
can be.
That's
And what
right.
that ultimately means is that the
What
mother and daughter.
what are we trying to accomplish here? Are we trying to
Trying to-
allow Mary and Joseph, who are brother and sister, and Joseph dies, are we allowing Mary to collect? Do we want to allow Mary to collect from the victim's compensation?
No,
That was not the intent.
that was not the intent.
It's.
Why don't we want to allow it?
You want to expand the fund.
But then you're gonna have to make sure that they are dependent, that they were dependent on each other, that they don't, yeah.
So the goal is to not allow brother and sister, Mary and Joseph, to collect if something happens to one or the other.
It's continuing to not allow,
Continuing to not allow them.
and that's okay, but this thing is wanting to let a domestic partner in.
But if they're not brother and sister and they're domestic partners, they can.
Yes. But they've only need to be together for 6 months, which in my mind is not really a real commitment.
So this is the definition that the state uses to define domestic.
You know, it
partners.
is,
that-
it is not exactly, but that was the basis for it, and Jen may have that language, I don't know.
Sorry.
Honestly, I don't like the policy, but I'm fine with it. If that's what you want to pass.
I'm not fine with it because it's only 6 months. I mean,
What do you want?
it's at least a year. No, 6
By
months.
the way, I
Moving in and
picked
out.
Joseph and Mary, I know why.
Was that your picture?
Were they parents of somebody?
It's, he's,
You didn't
Charles
get, that's why I
did.
said that, because I don't think Charles are gonna part of that.
They never lived together, probably. No one allowed it.
And not for 6 months, they certainly did.
well, we don't know.
I doubt if their family.
But wait a minute. She was, okay, I'm not gonna get into that.
You still have your records with you here?
No, I took them.
Oh, I want to look at them and figure it out.
Stephen did not get his name changed until December of 44.
Yes, and there's, you know, let's go offline and discuss that for a minute after we do this.
Yeah.
Because there's some things we should know.
Anyway, I'm good with the bill. I'll let it happen. Is there a
Yeah,
motion to
I'm fine.
report favorably? There's no amendment.
So, no amendment?
No amendment.
No, or you're gonna leave it the way that it is?
Yes.
Not,
Not
We'll
put in
agree
the
with
knot. The
with
knot
the
is
House of
wrong.
Representatives.
The knot is wrong. Philip's gonna have to learn that when he gets here.
We'll beat it into him. Or, but
Do
no.
you
but
think it should be a no?
I think because of this discussion right now, and now I'm all turned around, that we should clarify the language. I'm looking at the State Department of Human Resources, what they require for domestic partner. Would you like me to read that?
Yeah.
Is when you sign this to enroll your domestic partner, like in your health plan or whatever, requires that, they say in an exclusive and enduring domestic relationship while sharing a residence for not less than 6 consecutive months. And on that point, I remember the reason why they didn't go with the exclusive and enduring domestic relationship is that the board said it would be hard for them to be able to ascertain that. They are both 18 years of age or older. Neither one is married to anyone. We are not related by blood closer than would bar marriage under Vermont state law. And that's it.
Then why don't we just use that language instead of?
One of the concerns that came up about that enduring language, JLMC, this is Joint Legislative Management Committee, was, we didn't know what that meant. it sounded like it was born at a time when nobody trusted a civil union would be able to survive. And when you say the word enduring, it just is out there like, what are you talking about?
So you,
I'm a little bit concerned, Michelle, because this is paragraph 2 of the series, and I don't know whether some of the things we've been talking about are actually covered in 1 or 3 or 4, however many things are in the series. Just an observation.
I was ready to vote.
I think you should let me clarify the language.
I think that you should, and I think that you don't have to put the enduring thing in there.
Well, since you're
But
gonna
I'd
be
like-
here tomorrow in marijuana, can we clarify this between now and then? And you
Sure can.
presenting a copy of the statute.
Yeah.
Yep,
I'm voting no on this.
You're voting no because it's 6 months?
Yes.
Okay, well, you can offer an amendment tomorrow, make it 12, whatever you'd like.
Okay.
I was gonna ask you to report it, so I guess that won't happen.
Take care of that.
All right.
All right.